Hi, this is Charlie Rodeman. I'm an Austin criminal defense attorney, and I'm here with my law partner, Marianne Espiritu, also a defense attorney. And I want to chat about the driver's license hearing that is common with a DWI arrest in Texas. And it's called an ALR hearing, or Administrative License Revocation hearing. And one of the things that's interesting about Marianne here is that she used to work for DPS doing these hearings for them, against the defense attorney. So she has a very unique perspective on this. So tell us a little about this ALR hearing. Well, and for one, when does it happen?
So when a person is arrested for driving while intoxicated, if they have a Texas driver's license, one of the things that is implied is by you taking this little piece of plastic, you are agreeing to give a breath or blood specimen when an officer asks you, provided he's got what's called probable cause, and you cannot deny that. I mean, you can, but if you do, then there are consequences, and the consequence for the first time that happens is a 6-month suspension of your driver's license, regardless of what happens to the criminal case.
So you're saying if you refuse to give breath or you refuse to give blood, so that triggers this 6-month suspension.
Correct.
And that's going to happen if you 40 days after the date of arrest if you don't do anything, like just...
Correct.
That's what's coming.
And so the suspension is called Administrative License Revocation Suspension, ALR for short. And anytime the government takes something away from you, including your privilege to drive, you're entitled to be heard. And so that's where the ALR hearing comes in. But even if you cooperate and say, yes, I will give you a breath or blood specimen, the other thing that is implied when you take that little piece of plastic is you are promising not to drive with blood alcohol concentration above the legal limit. And so if you cooperate, but your blood alcohol is over 0.08, you have, violated your promise, and the suspension period is 90 days. And again, if they're going to take away your privilege for 90 days, you have a right to be heard, and so you get what's called an ALR hearing.
Right, but you have to request that, right? So if you don't, and you have 15 days from the date of arrest to assert your right to a hearing.
Correct.
Okay, or that if you don't, that's when the suspension starts on the 40-day period. Right. But like the 15-day, either you, the defendant, the paperwork they give you gives you a phone number. You can call and request your own hearing. Or what's better is if you have an attorney request it, and it's better if an attorney does it basically so it gets done absolutely correctly, and also then the attorney starts getting the notices of hearing and all the proper paperwork goes to the attorney. If the defendant requests it, DPS will send letters to them, and maybe you guys don't check your mail as much as an attorney checks their mail. So that's one, but you can request it yourself. Now, right. So what happens once we request a hearing?
So once we request the hearing, we get an original court date. It's just assigned to us. We don't get to pick it. And so we'll get that in the mail. And a lot of times, our calendar, we have things that are already in October. So we're always looking ahead. We have things scheduled ahead of time. And so this date that we don't get to pick could fall on where we have another conflict, or alternatively, we may not have gotten the discovery yet. We may not have watched the video yet. It's just an arbitrary date that they give us. And so a lot of times what we do is we ask for a continuance, and that is an automatic continuance. They will give us at least that continuance because they know that this date that they picked for us is arbitrary.
Right. So it would be typical for them to give us a date 3 to 4 months out, and then we take a continuance, and it's another 3 months or so. So
right.
So roughly 6 to 10 months away from the actual arrest date is when this hearing would happen.
Right.
And you don't. Our clients don't have to have this hearing. They can say, "I'll go ahead and let my license be suspended 40
Mm-hmm.
days after the arrest." What are some of the reasons that we typically try to talk people out of that? Like, what reasons do we give them to have the hearing? Because, and actually, this probably is important. It's hard to win that hearing. so
Right.
so we rarely win. Sometimes we do, but we
Mm-hmm.
rarely win because all that has to really happen is the officers show up and say, "I arrested that person for this reason," and that they had a reasonable reason to stop the person,
Mm-hmm.
okay, and probable cause to arrest them, which is, as we say in the lawyer world, a real low bar, right? And
Right.
so, let me ask you this: in the history of ALR hearings, have you ever had an officer show up and say, "I made a mistake and I shouldn't have arrested that person"?
Never.
Right there, they're never gonna say that. So okay, but I mean, there are situations where we can win if they mess up, really royally mess up, and we have
Mm-hmm.
evidence of them royally messing up. Um, anyway, so let's say that if it's because it's hard to win, why do we even bother having them?
Well, one of the reasons that I have found when somebody comes to our office with they have just gotten out of jail, they've just been arrested for DWI, and their world is turned upside down. Like now they have to hire a lawyer, and it's shocking. You're going along in your life, everything's going well, and then you're arrested. And so one of the main reasons is to just give you a breather. Like the last thing you need just is on top of everything else, hiring a lawyer, just getting out of jail, getting your car out of impound. Do you need to be suspended right off on top of that? And so, we request the hearing that stops the suspension, and at least you can not have to worry about being suspended while you sort everything else out. Sometimes you have to tell your job, you have to tell your spouse. So that is the last thing that you need is a suspension that comes 40 days after.
Right. So you just delay, push it down the road, and
Mm-hmm.
then we'll talk about this in a different video. But when you do, if you do lose or we lose the hearing and your license is suspended, there's almost always an opportunity to get an occupational license.
Right.
So you would be able to drive anyway. But people delay it. Another possible reason is that this hearing, we subpoena the officers.
Mm-hmm.
The officers show up, and we get to ask them questions. So we get to cross-examine them. We get to
Yeah.
learn more about the arrest that they didn't put in the offense report. And so often we're doing that uh, to use that information on the criminal case, right? So it's almost like you get a free chance to
Mm-hmm.
investigate the case, cross-examine the witness, and sometimes we discover stuff that can get a case dismissed. I mean,
Right.
occasionally, or better result because we go to the prosecutor and we say, "Look at this transcript of what the officer said at the ALR hearing," and the prosecutors go, "Oh, that's not helpful."
Yeah.
So there is the benefit of being able to cross-examine that arresting officer and stopping officer.
I agree. There have been so many things that I have found out had we not had the ALR hearing in any other offense. Like just say you're arrested for theft. We don't just get to call up the officer and say, "Hey, officer, I want to talk to you about this your arrest of my client for theft." But this is with a DWI. We have this hearing. We get to see how an officer would perform in a trial. We get to see, and they're under oath, and so their answers, this is sworn testimony, and if they answer one way at the hearing and then another way at the trial, that's a problem for them. I have found out that officers have quit the force uh, because of the ALR hearing and us not being able to subpoena. I mean, an officer not being with the agency where they arrested our clients, that's a big deal.
Yeah, that's helpful in the criminal
Mm-hmm.
case.
Yeah.
Um, well, so these hearings, if they're our clients, we basically will be able to tell them when the hearing is,
Mm-hmm.
and then we will go without them, right? So people don't have to go to this hearing.
That's correct.
Okay, so it's
Right.
just the attorneys show up. And then the way this works is the hearing happens, and then the judge gives us a ruling a couple days later. They fax us over a ruling, even though we kind of know after the hearing what's going to happen, because if the officer showed up and said the few things they need to say, we know we lost. But it's still, the judge will send us a result a day or 2 or 3 later.
Right.
And then that's when we go into the next phase, which is getting our clients an occupational license that
Right.
we'll talk about in a different video.
Okay.